Please rise. The Justice of the Appellate Division, Supreme Court, first to talk. All persons having business with the Appellate Division are near, is attended, and you shall be heard. Please be seated.
Good afternoon. Welcome to the Appellate Division First Department. As I call the calendar today, please ask for the time you actually need. And remember that the panel, if we have additional questions past the time you've been allotted, we will ask them, and you'll have a chance to answer. You read your papers and are familiar with your arguments. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you have asked for less than 2 minutes, it will go on immediately. When I call your case, rise and let me know who you are representing and how much time you are requesting. People v. Del Campo, submitted. Forbes v. City of New York.
Appellate requests 4 minutes.
You know the other side's not here.
Correct.
Okay, 4 minutes. S. Isaiah is submitted. Delon versus Cow. 4 and 1 and 3. Cobblestone Holdings v. 41 Fifth Avenue, Fifth Owners. I'll give you 6 and 2 and 6. Thank you. People versus Nasir Jessamy. Submitted. People versus Swu Sharif. 5 and 2 and 5. AWL Industries versus New York City Housing Authority. 5, you said? 6 and 2 and 5. People versus Cpio. Did you say 4 and 1? 4 and 1 and 4. Weld versus New York City Department of Environmental Protection. 6 and 2 and 6. Actually, I'm going to say 5 and 2 and 5. American Empire v. Hudson Insurance. 4 and 1 and 5. Beton Court versus City of New York. 5 and 2 and 5. Torres v. City of New York. Submitted. People v. Shaquan Brown. 7 and 2 and 7. Cox v. 36 South Oxford Street. Cox? Okay, 4 it is. People v. James Wells. Submitted. Okay, first case up is Forbes v. City of New York. What's it?
May it please the
Hold on a minute, counsel. Yeah, for formality's sake, counsel, hold the thought. Geico v. Liriano is on submission. State of New York mortgage is on submission. Okay. That's all right, no worries.
May it please the court, I'm Janet Zalian for the city. There was no reasonable justification for submitting the eyewitness's affidavit on renewal for the first time. In fact, the Supreme Court did not ask for any, did not try to apply that standard, did not address that standard at all. And the plaintiff, with very little effort, could have located Ms. Wright earlier to see if she was recanting her
But
testimony.
why would he have known to call Ms. Wright? He knew she was a reluctant witness, but she hadn't said anything about coercion. In fact, she'd said something to the opposite at the trial.
But he said, plaintiff's counsel asked the detectives during their depositions, and I think Detective Rogers was in 2019, even before the pandemic. Did you hear that Ms. Wright was recanting? And he said no. So why didn't he try to nail it down at that time? He had nailed down the other witnesses' recantation in 2017 and 2018.
That was
Wait,
the Reverend Diamond?
He asked the detective, did you hear someone was recanting? And the detective said no, and that was his indication to further pursue Wright?
Well, he himself was recantation was on his radar. And
How was recantation on his radar? Because what I understand is that the witness testified at trial against him, identified him at trial. How's recantation on the radar?
well, in other words, in the civil case, he was already looking at that issue. He didn't try to depose her.
But you keep saying this in this conclusory fashion. Where in the record is it clear that it was on his radar?
Well, he didn't say it was on his radar. He asked about her recantation. So that, why would you ask it without, and if you think that might be a possibility, remember, she lived in the same apartment the whole time. His investigator had found her there at the outset of, before the...
But based on all of the things that we've heard from Mrs. Wright from the trial, what and her grand jury testimony, what from that would indicate that there was a recantation, aside from this one question that was asked to the detective?
Well, the question is, if there was some reason to think that she might be recanting, why wouldn't he try to contact her? Why
That's precisely
wouldn't...
the question. What was the reason? Why would he think that she was recanting?
Well, that's it. We don't know, but why wouldn't he try to find out? Because it's his burden on renewal. If he had submitted her affidavit on summary judgment, that would be a different idea. But the reason for renewal is that when you grant summary judgment, it's generally supposed to be, that's the decision. So under CPLR 2221, and this court has held, like in the Orchard Hotel case that we cited, that you have to have a reasonable justification for explaining that with due diligence, you could not have located this, whatever the new information is in a given case.
And there is no reasonable justification here.
Excuse me?
And your argument is there is no reasonable
Right,
justification.
and it is the plaintiff's burden as the movant on renewal to show that reasonable justification. Ms. Wright's affidavit talks about what she says the police said to her that was a threat, but she doesn't say anything. It's counsel says that there was first, before Supreme Court, counsel says that there was a relative that she contacted, relative of Forbes. There's no affidavit from anybody describing that or saying when that was. And in the respondent's brief on appeal, Forbes says that that Ms. Wright talked to his lawyer, and again says nothing about when that was. Does the court have any further questions? In that case, we'll rest on our brief and ask the court respectfully to reverse. Thank you, Your Honor.
Thank you very much. Delon versus Cow.
Good afternoon. May it please the court, Patrick Lawless for the defendant's appellants. This summary judgment motion was initially made prior to any discovery being taken, the court initially denied, and correctly denied, the motion, finding that the different accounts
Yeah,
of
but
the
it
accident.
revisited that, of course. That's why we're here.
Yeah.
And so what was the non-negligent explanation that Mr. Cow provided for the accident?
The non-negligent explanation he provided was he was entirely within his lane the entire time.
Wasn't he merging into another lane, though?
No, that is the testimony, that is the affidavit. According to
Right.
the affidavit of the plaintiff and a non-party witness, he was merging into another lane. But according to Mr. Cow, he was never merging into another lane. He was entirely within his lane the entire time, and that the plaintiff must have cut directly in front of him at the time.
When you, oh, go ahead, please.
Did the affidavit from Mr. Cow indicate anything about a rear end collision? Or did he say that he didn't even know if he had hit anyone?
He said he was entirely within his lane. He initially didn't know that he had struck, that there was any contact, because he was entirely within his lane, and the plaintiff was driving a small
If you're going
car, but
5 miles an hour, though, and which you would concede, they're roughly going 5 miles per hour, right?
he said he was
Yeah, and I
traveling
think
between
that's
3 and 5.
consistent. All the witnesses said that. But if you watch the video, he's pushing the car, the plaintiff's car sideways on the George Washington Bridge. I mean, how do you not know that you collided with somebody?
That, it wouldn't matter, because for that to have happened, the plaintiff would have had to have cut directly in front of him. Because according to the plaintiff and the non-party witness's account, especially the non-party witness states that he was in the center lane directly behind the plaintiff the entire time when Mr. Cow's truck cut in front of him. But if you look at the video, the non-party witness was in the extreme left lane, and there's a barrier next to him. He's not in the lane directly behind the plaintiff. You see the plaintiff's vehicle completely perpendicular, and you see Mr. Cow's truck completely within the lane to the right. So he's not merging.
And there were 2 lanes too, right, would you say, in that area?
In the video, you can only see 2 lanes. It's unclear if there was another lane beyond the truck.
Yeah, so the inference that I drew from that was that that Mr. Cow had merged into the lane on the rightmost side. That's not, I shouldn't draw that inference?
I don't think you can draw that inference, and especially when you see the truck. This is a large tractor trailer entirely within that lane. It's not angled in. It's not cutting across the lane. And initially, according to the plaintiff, Mr. Cow, the plaintiff, Mr. Catrozola, Mr. Cow's truck struck the rear of the plaintiff's vehicle, and there's no damage to the rear of the plaintiff's vehicle. And again, you only see the plaintiff's vehicle completely perpendicular in front of Mr. Cow's truck.
In the video, go ahead, sorry.
So the witness says that they saw the tractor trailer proceed past the end of the merged lane. Could that be consistent with Charles' statement that he didn't switch lanes? Instead, he came upon what is the end of a merge lane?
He never indicated he came upon the end of a merge lane. He just said for 5 minutes he was within the same lane the entire time. And I believe, according to his affidavit, there was another lane to his right that he was traveling in. So I don't believe that would give the inference that he was in the merge lane.
You're saying according to his testimony there were 3 lanes then?
According to his affidavit, there was another lane to his right, I believe.
But if you look at the video, part of it shows that to the right, there's no other lane but sort of like a barrier to the right of where the truck was proceeding.
I believe in the video it's clearly there's a barrier to the left. It's unclear.
And there's
because
a barrier
cars
to the
and
right.
There's a truck. Whether you can see a barrier to the right of the truck, that's unclear. But what the video does show is that Mr. Cow's truck is completely within his lane, and the non-party witness who said he was directly behind the plaintiff is in the left lane.
Well, he
So
said
if
he
was
didn't
behind
begin. He said he didn't begin to record until the defendant's truck was pushing this smaller vehicle for a considerable period of time, and that's when he started filming.
That's what he says, but he also said he never says that he changed lane and he switched to the left lane after the incident. He said he was behind the plaintiff when Mr. Cow's truck merged into him and struck. He never said, I was in the left lane or I switched to the left lane to film this. He said I was behind the entire time.
Right. So he started filming after the witness started filming after he had switched lanes and had a better view of what was occurring in front of him.
Well, let me just follow that up before you answer. Is it your position that the plaintiff didn't even make out their burden and therefore Cal's affidavit doesn't need to raise a non-negligent reason?
Well, that's our argument, is that there's discrepancies within, between the photographs, the video, the plaintiff, and the non-parties' affidavits, so therefore summary judgment should have been denied. But at the very least, Mr. Cow's affidavit contradicts them, that he was in one lane the entire time. And again, this is just all an issue of fact, and no discovery has taken place. We haven't had an opportunity to depose the plaintiff, the non-party witness, or Mr. Cow for more details as to what happened. There are more questions than answers.
Thank you, counsel. You have time for rebuttal.
Is that good?
Please.
Thank you. May it please the court, Lori Parkman for plaintiff respondent. It's clear in this case that plaintiff did meet his prima facie
Well, there was
burden.
no damage to the back of that vehicle, looking at the pictures, at least from my view. And the video does show the car perpendicular, not a rear end push, as might be expected based upon what is alleged to have been the cause of the accident. How do you explain that in terms of beating your burden for summary judgment?
Well, that the car is perpendicular, that's completely consistent with the plaintiff and the eyewitness's account that the truck merged from the right, hitting the rear and turned it. That's a truck coming from the right would hit the right rear and turn it, as you can see in the video, then it's perpendicular. That's completely consistent with the lane change that the plaintiff and the eyewitness spoke to.
The plaintiff and the eyewitness say that the tractor-trailer merged.
Yes.
The tractor-trailer driver says, I didn't merge. Isn't that an issue of fact?
No,
Why not?
well, the defendant truck
How
driver,
do you reconcile the two?
well, if the defendant didn't notice that his merge lane was ending and that he was merging into the left lane, that's just more.
I think we should separate, or at least I would like to separate what the tractor trailer supposes happened, because it's clear he didn't realize he hit someone, right? I think the video shows that. But that aside, that does nothing to whether he merged or not. He's saying he did not merge.
Right. I would say that that's just more proof of his negligence, that he didn't notice his merge lane was ending. But even if,
Your argument is that he didn't notice he merged.
but even
He's
if,
saying he didn't merge, that we should not take that at face value.
no, right, exactly. First of all. Second of all, even if he had been completely behind plaintiff in the same lane and there was no merging happening whatsoever, that's still not a non-negligent explanation for why he rear-ended and hit the plaintiff's vehicle. The only non-negligent explanation that he posits is, oh, plaintiff must have come from a different lane and cut in front of me, and that's
So your
pure
position
speculation.
is that because his affidavit doesn't definitively indicate that plaintiff came from the left or the right and went in front of me, and that's why my vehicle hit the plaintiff's vehicle, because he doesn't say that or something to that. He says, I don't know what happened, I didn't see it.
Right, well,
He couldn't raise a non-negligent reason.
the case law from this court is clear that if a defendant driver does not see the plaintiff's vehicle prior to the collision, here he didn't see it prior to, at the collision, after the collision for a while, that any positing as to the movement of the plaintiff's vehicle is pure speculation. I'd point you to the Mora case and the Velasquez case from 2015, uses the same language, that the defendant's testimony that he, quote, believed that the plaintiff must have cut in front of him was pure speculation, insufficient to raise a triable issue of fact, because he admitted that he did not see it. And here, they use the same language.
Thank you, counsel.
Thank you.
Counsel, can you respond to her last argument?
About not seeing?
About not having a non-negligent reason and our case law here in the Appellate Division First Department.
Well, I believe he did put forth a non-negligent explanation that he was within the same lane the entire time and didn't switch lanes, and that the plaintiff, because the fact that he didn't see it, if the plaintiff suddenly accelerated in front of him,
Doesn't that leave a gap, right? Because even if he's saying, I'm within the lane, undoubtedly he made contact with another car and pushed it without knowing that he was pushing it for several feet. How does that get explained?
because if the plaintiff suddenly cut in front of him,
And that's the thing, we're presupposing that, right? And there's nothing to establish that, and what we have is the plaintiff saying that he was rear-ended.
But if-
What combats that?
there's absolute, in the photographs, there's no damage to the rear of the plaintiff's vehicle. And for the accident to have happened the way that it did, the plaintiff would have had to have cut in front of Mr. Cow's truck.
And he could
If
have
he's-
said that, but he didn't.
I'm sorry?
He could have said that because he would be the person who knows that. He could have said that in his affidavit, but he didn't. Instead, he says he doesn't know what happened.
Well, he says he doesn't know what happened, but if he's within the same lane the entire time and didn't attempt to merge into the plaintiff's lane and didn't strike him in the back, then the only way the accident would have happened is if the plaintiff would have cut in front of him. That's the only way the accident could have happened. That the fact that he didn't see the plaintiff suddenly accelerate into his lane doesn't mean that he was negligent, because it would be the plaintiff who would have been at fault for changing lanes when it was
Thank you,
not safe
counsel.
to do
Any
so.
other questions?
No.
Thank you. Thank you both. Cobblestone Holdings, the 41 Fifth owners.
Good afternoon, Your Honors. Howard Grun for Appellant. The court below had denied Yellowstone relief to the plaintiff here, and for good
Counsel,
reason.
Maybe we should start with, is the second amended complaint substantively different than what was in front of the trial court?
It repeats the essential allegation that's at issue here, which is what do we do with the percentage formula in the leases? And it claims that those percentages need.
Different causes of action, though.
No. They ask for declaratory relief. They ask for.
That's it.
and
Was
they're
there a breach of contract in the one that was before the court? Was there a breach of contract cause of action?
In the original complaint?
Yeah.
Hard to tell because it was not really pleaded well, but it asks for injunctive relief, declaratory relief, and hints about the fact that the contract needs to be reformed. I think if you look at that first complaint,
I
it's
thought
essentially
that it
reformation.
asked, the first complaint was about barring the landlord from terminating the lease, and then the second one spoke more about not being required to pay the disputed amounts, and that the landlord didn't provide sufficient documentation to substantiate the increased maintenance charges. Why isn't that different?
So there are two different things here we're talking about. In the first complaint, the allegation is that the percentage formula in the leases are not related at all to the actual relationship between the size of the premises and the size of the building. We've argued that that's not appropriate. The leases are the leases and the percentages are what they are, and they're enforceable. The second amended complaint repeats that claim. Paragraphs 17 to 20 and 32 in the amended complaint say the same thing. And what they're saying is these percentages are unfair. They need to be reformed.
Right, but in the second amendment, don't they also say that the defendant has not provided documents to substantiate the amounts demanded in increased maintenance charges? That's different than what the percentages
yes,
are.
and different claim entirely. And frankly, there are two things going on here. If you go ahead and agree with us that the percentage formulas are sacrosanct, they cannot be challenged, statute of limitations, this is a 40-year-old lease. If the percentages are applicable, but the accountants have to sit down together and figure out the numbers. If they're going to claim that there's a mistake in the accounting, that the expenses have not been calculated properly, entirely different case, that can go forward, and that's easy enough to resolve. The parties can sit down and probably resolve the case in 5 minutes because it's just numbers. The essential claim here is that the percentages don't apply. And if the percentages don't apply, then the entire lease has to be reformed. That's not appropriate. And the lower court found that, denied the Yellowstone relief, and said, it is indisputable that the leases say what they say, and you will not win. You're in default. You haven't paid, and this claim that the percentages are not enforceable is wrong. So the next logical step would be the cross motion to dismiss based on that same document should have been granted. It was not. The court said there were no documents to support the claim, but in fact, the very same documents, the lease was in front of the court and was used to deny the Yellowstone relief. So between that documentation and the statute of limitations defense, cross motion should have been granted. Now, yes, there's a second amended complaint, and it alleges other things. It's a far better job than the first complaint, and it knocks out all the sort of allegations that we had to deal with, which were really not applicable. But as I said before, the bottom line here is, if it's a numbers game and the financial people have to sit down and go through the numbers, that's okay. But to then say that we need to recalculate the percentages and remeasure the building and remeasure the space, that's barred by the law. The law says you do not do that. Commercial leases all the time have indexing features. People agree to index the rent escalations by porter wage escalations. No porter wage may be involved in the space at all, but it's an easy way to see what's owed. Same thing here. Percentages are set. 40 years ago, they were agreed to, and that has been the case till today. And in 2014, when this plaintiff came into the space, they knew what was going on. They saw the leases. They made a business decision to buy and to take the assignment of the leases.
You make the point that the percentages are in the offering plan as well.
And they were in the offering plan, and it was set forth entirely that this is going to be the percentages in the leases, and they were. And there's been nothing inconsistent in the 40 years. This plaintiff has been paying those percentages since 2014. It's only recently now, and if you read the original complaint, they're talking about trying to sell their space and assign it to someone else. They'd like to get a windfall. We'd like to make this cheaper. Economy's tough. Business is difficult. Let's see if we can knock these percentages down a bit and get a better offer. That's not appropriate. So that's where we come in terms of saying the percentages have to stay. The fact that there's a second amended complaint doesn't moot the appeal whatsoever, because the allegations in the new complaint still mirror the old, and therefore the appeal should be decided. And if in
Thank you,
fact,
counsel. You have time in rebuttal.
thank you, Your Honor. Thank you.
May it please the court. Kevin Schlosser for the respondent. Should the Appellate Division First Department be rendering a decision based upon a pleading that has never been reviewed?
But isn't the Second Amendment, you heard the point he made, and you read his brief, the Second Amendment complaint is directed toward the same basic claim, that maintenance escalation calculations are either incorrect or unconscionable. I mean, it's the same, that's a sort of like your fundamental claim, isn't it?
So there's two points here. One is, what does the complaint allege, and has it satisfactorily alleged a cause of action? And this clearly does, because it alleges, among other things, a declaratory judgment, breach of contract, the violation of the real property, and unjust enrichment. So allegation-wise, that complaint is a well-pleaded complaint. What the defendant is saying now is that they have submitted documentary evidence that conclusively resolves all the issues presented by the second amended complaint. And no court has rendered that determination. No court has reviewed the documentary evidence that they submitted against the very first complaint, where the court evaluated a pleading that is completely different than this complaint. All right? So this court would have to determine that they have effectively submitted documentary evidence proving that there is no cause of action whatsoever that could be alleged, that there is no cause of action. And the cases they cite, Your Honor, the cases that they cite are summary judgment cases. The J.C. Penney case of the lower court 45 years ago was a summary judgment case. The Barker case, George Barker, was a summary judgment case. They're relying upon cases that reviewed specific lease language.
Yeah, but they're also relying on the law, and the law is, I don't know, there's a lot going against you on that, it doesn't, the percentage amounts don't have to align with square footage. We got accurate copy is a good case on that point. In other words, you're stuck with what's in the lease.
But here, and Your Honor did mention that the offering plan is incorporated, and the offering plan makes clear that the intent of the parties was it was supposed to track the actual square footage in the space. And that, to me, presents a different question than the other cases that analyzed a specific lease provision. All those cases are good for is holding that you need to apply the specific language of a lease. The parties can't change that. So all I'm alleging or urging is apply the specific language of this lease, let the lower court make that determination, and if it ever comes up on appeal again, you have a full record of the evidence, the lease provision, and an actual determination to consider.
Thank you, Counsel. Any other questions? Thank you very much.
Very briefly, Your Honors, it's important to note the offering plan doesn't say anything about exactitude. It says these percentages are meant to reflect the approximate relationship between the two items. And that's just to give people some context about what's going on. But there was never a representation that this was going to be an exact measurement, space for space, foot for foot, and inch for inch. So when the percentages are set forth in the leases, they're consistent with the offering plan and, in fact, are enforceable as the law says forth. The other issue is that because the current amended complaint has the same allegations as I mentioned in paragraph 17 to 20 and in 32, Cobblestone maintains that the percentages used in seeking in the disputed charges do not conform with the lease and so forth, with the provisions. That is an exact replica of the claims made in the original complaint. So the fact that they've amended it twice since then doesn't mean the court can't dismiss the original complaint and can't make a ruling that the percentage formula are legitimate. They then have the burden of amending their complaint again or starting a new case in a way that's consistent with this court's decision, which would be the percentages stay in place. You want to argue that the numbers are incorrect, go ahead and argue it. As I said, that's easy. That's just the accountant sitting down and going through the numbers. But the legal issue is very important, and that, I think, the case law definitely supports our claim about the sacrosancticity, if that is a word, of the percentage formula. Thank you, Your Honors.
Thank you. Thank you both. People v. Swu Sharif. Hold on one second, Counsel.
No problem.
Please.
Good afternoon, Your Honors. The Legal Aid Society by Megan Teschler on behalf of Mr. Swu Sharif. The SORA court erred when it denied Mr. Sharif, a first-time offender with a pristine prison record and no substance abuse issues, request for a downward departure from a level 2 offender to a level 1 offender. First, the SORA court erred when it failed to give due consideration to the mitigating circumstances and Mr. Sharif's scores on DOCS's COMPASS instrument. With respect to the COMPASS instrument, the court—
What does our case law say about the probative value of that COMPASS instrument? And I'm directing you particularly to People v. Castillo, which this court decided in 2022.
Yes, Your Honor. Although this court and other courts have said that instruments, these alternative risk assessment instruments in and of themselves are not to be considered solely a basis for a downward departure. Instruments like the COMPASS instruments and other instruments like it can be used as a factor in a totality of circumstances analysis to show that an offender is deserving of a downward departure. And the SORA court here disregarded the COMPASS instrument, and he said it's prepared for entirely different purposes, and anyways, all of those factors already are taken into account by the RAI.
Certainly, the absence of a criminal record is already accounted for, right, in the RAI?
Your Honor, with respect to the RAI,
I'm just asking about the one thing, the fact that he didn't have a criminal record. That has been accounted for. It was in front of the SORA judge, wasn't it?
The RAI accounts for negative types of behavior, such as whether an offender has committed certain offenses, but My argument here is that, and I will not put it as eloquently as Judge Rivera does in her dissent in People v. Anthony, but the RIA focuses on conduct that is negative behavior, but it doesn't take into account mitigating conduct that corresponds with the negative behavior accounted for in the RII. So for example, Mr. Swale, who has absolutely no criminal record, and he has a pristine prison record, and while there are perhaps corresponding factors in the RII, the pristine prison record and this lack of a criminal record and also lack of a substance abuse show that he really doesn't have these factors, and they are mitigation and they should be taken into account. And in fact, other courts have taken these types of factors into account. Courts have said,
Yeah, but I'm not sure we have done so where the aggravating circumstances are so severe as here. And here the victim kept a journal, so it's rather well documented that, you know, he raped her and sexually abused her for 2.5 years, and she was starting when she was 14. So those are very serious facts that you have to overcome.
while those are serious factors, and I agree with Your Honor, there are mitigating factors in this particular case. And just because someone commits an offense doesn't mean that they're going to commit a similar type of offense.
So what are the mitigating factors that the court didn't take into account? The compass?
The compass instrument and the factors contained within the compass instrument, which was submitted by defense counsel during the SORA hearing, and also Mr. Swale, who
You're
had...
saying that it's not enough that the RAI didn't assess any points for past conduct because he had none, and for his pristine prison record because it was pristine. You're saying that's not enough, that the scoring of no points, that in fact there should be mitigation, and to put it, I guess, in general terms, there should be a deduction of points. He should have credit for that.
I'm saying in certain circumstances, Your Honor, when a prison record is pristine, when someone has no criminal conduct, I am saying that the RII only takes into account negative behaviors, and courts have taken into account these very specific factors, such as someone's...
But you concede that the purpose of compass is materially different than the RAI.
The purpose of compass is to assess someone's risk level and to put them on an adequate amount of supervision, which, Your Honors, so there's level 4, level 1, and it determines...
Wasn't he assessed here at the highest level at the compass?
Initially, he was assessed the lowest level, but
It was overwritten, right?
it was overridden because this was a sex offense, but the compass instrument...
Which is an indication that compass was not really designed to indicate the likelihood of recidivism when it comes to sex abuse.
I think that compass is a tool, one of the many tools that courts can use in order to determine the full picture of what...
Correction uses it for general reintegration into society, right?
Corrections uses it to determine what an offender's needs are when they reenter society, correct, Your Honor? And it can be considered, it's just one of many things. As the guidelines themselves say, the RAI doesn't take into account every factor, which is why these alternative risk assessment instruments are important tools for a court to use as mitigation evidence. And this court disregarded the compass scores as just taken into account by the RAI.
So you make that point very well in your brief, and you can do some more if you wish on rebuttal. Thank you.
Thank you.
May it please the court, Rafael Curbelo for respondent.
Mr. Carvello, let me ask you this. Has the RAI considered sufficiently the, in item 4, continuing course of sexual conduct, the allegation that this child was raped over 50 times based on her diary by this defendant over a course of anywhere from 2.5 to 3 years?
No, Your Honor. I think that the people could have, had they decided to argue for an upward departure, for that as an aggravating circumstance is not adequately accounted for in the...
So do you think that this particular aggravating circumstance sufficiently outweighs any mitigation that this defendant may have presented?
Yes, yes.
Particularly when he says in the pre-sentencing interview that the victim was his friend and that he was going to divorce his wife.
Correct.
And he also tells the Department of Corrections and Community Supervision that the victim consented to the sexual conduct, correct?
That's right. He evinced a lack of appreciation that a minor cannot consent. And so that kind of goes to his dangerousness and the risk of sexual recidivism. I mean, he offended her, he sexually assaulted her at least 50 times. So in terms of the risk, the dangerousness, the risk of sexual recidivism, even if you were to take the compass into consideration, those mitigating circumstances do not outweigh the seriousness of the crimes here.
That argument aside, how do you respond to your adversary's position that the lack of a criminal record, his pristine record while he's incarcerated, that while the RAI doesn't attach points to it, that it also doesn't consider it mitigation?
I would say, well, to quote Judge Rivera in her dissent in People v. Anthony, she wrote that she spoke in terms of positive rehabilitative behavior. So not the absence of a bad deed, but the presence of a good deed. There's a difference between having a clean record and volunteering and getting certificates and helping other inmates rehabilitate themselves. I would draw a comparison between the arsonist and the firefighter and the spectator. So the arsonist is going to get docked points for starting the fire. The firefighter may be credited for putting out the fire, but the spectator who did neither, he's not going to get points added or subtracted. So I think Judge Rivera put it well in terms of positive rehabilitative potential, not merely the absence of negative behavior. And if there are no further questions, I ask that this court affirm.
Thank you, Counsel.
So with respect to the positive rehabilitative behavior, I just want to point out that not having a criminal record is not committing crimes, and a pristine record.
Also, did you argue the lack of criminal record to the lower court?
I did not do the SOAR hearing, Your Honor, but I believe SOAR counsel did argue, and that was one of the factors taken into account by the compass instrument, and she also referenced it in her application for a downward departure, as well as submit the compass instrument into evidence as Exhibit A. And I would argue that, again, courts have, in fact, taken these very specific factors into account in downward departure requests. One case I cited in my brief, the court said acceptable conduct while incarcerated was one of the mitigating factors as a basis for a downward departure. No sex crimes in a criminal record. Perhaps the defendant had a criminal record, but lack of sex crimes is a mitigating factor in support of a downward departure. So all of
even if the risk assessment instrument has not assessed any points, that would be considered separately?
that is my understanding of, yeah, he did not, the offenders in these cases did not receive points, but this court has considered the lack of sex crimes offenses particularly and acceptable conduct as a totality of circumstances analysis, one of the factors in a totality of circumstances analysis.
So when we look at the big picture here, when we look at the entire picture, and we consider what the risk assessment instrument has already captured, right, because he was not assessed points, and we consider that he was not assessed points for aggravating factors, so doesn't that sort of like even out? And we leave it alone.
My argument is that the RAI focuses on factors, negative behaviors. It does not consider mitigation evidence, and pristine records, lack of criminal records, lack of substance abuse, although they are referenced in the RAI, they are mitigating factors because the RAI concerns itself only with negative behavior, but not mitigation, not lack of certain types of behavior. So I'd argue that mitigating factors, even though they relate to other factors in the RAI, can still be considered under a totality of the circumstances analysis when considering a downward departure, Your Honor.
Thank you, counsel.
Thank
you
you.
both. AWL Industries versus New York City Housing Authority. Please.
May it please the court, Amanda McLaughlin for Appellant, New York City Housing Authority. The court erred in holding the contract was not documentary evidence and overlooking the abundance of appellate precedent of this court.
Was that like an authentication issue, or was it a hearsay issue, or was it some combination of the two?
It's sort of unclear. Obviously, a contract is not going to be hearsay. Both parties agreed to it. It's an out of court. It's a legal document. But neither side made an argument arguing that the document was not authentic. In fact, AWL has never said that it was an inauthentic contract.
Both sides used the contract to make arguments, right?
Yes, Your Honor. In the complaint, in opposing the motion, even in the appeal itself, both sides cited to the contract. So there is no actual argument by either side that the contract was inauthentic. And it should have not been the basis of the determination of this case. And as well, despite finding that the contract was not documentary evidence, the court below went on to use that contract in making findings in favor of AWL's argument. And then they used the contract further to proceed to make additional findings. And in fact, the court below committed reversible error by failing to dismiss AWL's complaint for failure to comply with the contract's notice of claim provision. For well over 20 years.
So a lot of the, do you guys use the term PCOCO for the change orders? Well, I just want to know, it's the acronym.
Some people do, not everyone actually phrases it that way.
I'm not going to sound out PCOCO. So the PCOCOs, I mean, there was one thing that you grieve about them is that they didn't contain quantified amounts that would be caused by the change order. Is that correct?
Correct, Your Honor.
Okay, and was there one that did?
No, there is not one single proposed change order that included damages.
The pump, the vacuum pump?
There is one notice of claim that included proposed damages, and that was the vacuum pump one.
I see.
But it wasn't in the change orders. It was in the notice of, it's titled Notice of Dispute - Claim. So there is no proposed change order that contained damages, so those cannot be notices of claim.
Where does the e-builder system come into play in terms of the timeline? And if there's no space for an amount, how are they supposed to enter it? Or is that not a proper form of notice? That's 3 questions, I understand.
So e-builder is, I don't know what year we started using it, but it's the system we use now for all of our construction contracts. Pretty much they do everything in there, so you can look up the contract documents in there, you can submit proposed change orders, whatever you need to do, that's where you would do the paperwork.
You submit notices of dispute?
You could, but it wouldn't comply with the contract if you did it that way, because you're supposed to do it in writing, you're supposed to either serve it or mail it a certain way, and it's supposed to go to the contracting officer, not into the e-builder system, but nothing's stopping you from putting one there as well, and then also sending it out with your process server, however you want to do it. And then the other part of your question about the contents of a proposed change order, it's a blank. They could have typed in anything they wanted in the blank. If they had wanted to type in, this is also a notice of claim, and our proposed our amount of damages is such and such, and the damages are based on this, they could have. But they didn't do that. It's just a place where they can type in whatever they're making.
You just said it still wouldn't be enough, right?
It has to be labeled a notice of claim, it has to contain the damages, but it also has to be given to the contracting officer.
Where does the e-builder system go? I mean, so I guess the contract does say mail or service.
Yes.
Right? But where does the e-builder system go? Who gets that?
It just exists on the internet, essentially, and you have to be, as an individual, given access to e-builder. So
then the affidavit from plaintiff's president that references and details the e-builder system, in your opinion, that's not something that the court can consider as to whether or not they complied?
You can consider that the description of e-builder, but it doesn't change the fact that the proposed change orders don't meet the requirements of a notice of claim. They don't have damages, which is a basic requirement of a notice of claim. So no matter how the system works, if you wanted to look at their 2-step argument about e-builder, it still doesn't change the fact that no document they submitted meets the requirements of a notice of claim.
And before they can bring any type of action, they need to have, that's a
Correct, Your
condition
Honor.
precedent. The notice of claim is a condition precedent.
Yes, it is, Your Honor. This court has held that strict compliance is required in order to bring suit.
But if I understood you correctly, although there is no space to put the amount on e-builder, there is a field that they could have manually entered it anyway.
Yes, so there's no spot that says this spot is for a dollar amount, but there's a spot where they can put the entire description of why they're making a proposed change order. It's not limited, they type it all in.
Did Supreme Court reject your no damages for delay argument on the basis that the contracts were before her? Is that the basis? The no damages for delay defense that you have as well, based on the contract language. What did the Supreme Court do with that?
So they relied mostly, I think, on that they weren't really making any decisions because they weren't looking at the contract. But then upon looking at the contract, it seems that they were focusing mostly on the very, very limited exceptions to enforcement of no damages for delay clauses.
Is COVID one of those?
No. So that's actually been addressed previously in another case that is not an unexpected. Plus, if you look at our contract, it actually says, may I continue?
Please.
It actually says epidemics are a possible cause of delay and that you can ask for a time extension for that. But that doesn't undermine the no damages for delay provision, nor does it create an exception to the no damages for delay provision.
Okay, thank you, Counsel. You have time in rebuttal.
Good afternoon, Your Honors. Timothy Comiskey for the respondent plaintiff. Before I begin, I'd like to say that the statements that were made by counsel pertaining to how the e-builder worked were never put into their brief. It's not part of the record. In fact, we put that forward. They didn't talk about how that form is filled out. AWL did. But I'll get to that in a moment. This is about contractual interpretation. This is a contractual framework case. None of the First Department cases before dealt with e-builder or dealt with...
It's not mentioned in the contract. I mean, there's a specific way that you have to serve this notice by service or by writing. It doesn't mention e-builder.
So, yes, Your Honor. So, NYCHA compelled us to use the e-builder program. They trained us in it, and in fact, the change order process was also part of that. That is in the record on how that worked. In addition,
So
and most
Mr.
important...
Pavlovich is who you're relying on for that,
Yes,
correct?
yes, yes.
Does he say this is how it was done, how I was told
Yes,
to do it?
so number one, I'd like to just state that the contract documentation, and the First Department has never addressed this, and that's part of the Carlton Manor project here, is that a modification, which is a change condition, it states explicitly that the contractor may initiate a claim by filing a proposed change order. Then, because this is an e-builder case, most importantly, NYCHA created the change order form. NYCHA created it. And within that change order form, it also states that a change order is a claim. So the contractor is complying with NYCHA's contract terms. Your Honor,
Counsel, I hear you're relying on the contract, so you would concede that Supreme Court erred in excluding the contract?
Well, the Supreme
Yes
Court...
or no? I mean, she did talk about it, right?
The Supreme Court initially made the argument that defendant's motion was not admissible because defendant's attorney affirmation was not the vehicle to admit the documents, so they were unauthenticated. That's what the court said on that.
I mean, and I read your brief where you kind of artfully stated the same thing that you just said, but you didn't take a position on it. I mean, to answer my colleague's question directly, could you?
I'm sorry?
What's your position on it?
So here's what happens with the change order that we're complying with NYCHA's contract. The proposed change order gets filed on e-builder. Everybody at NYCHA is a recipient of every document that's filed through e-builder, including the proposed change order that they prepared and instructed us to file anytime there's a change order. So what NYCHA does is it goes through a number of units, and that's in the record, Your Honors. The proposed change order guide, the e-builder guide states that, what departments it goes through. And Counselor's wrong, and it's not, she never made this argument below or in her appeal brief. What happens with that form is it goes and gets filed on e-builder. NYCHA's recipients, including the contracting officer, all see this. It goes through a process. If they approve it as a change order, the box for the amount of the damage opens. And what happens is there's a negotiation between AWL and NYCHA on that amount. That's their procedure. So what happens is they have to approve it, then it's negotiated.
So was there anything preventing you from providing the cost outside of eBuilder?
So here's what happens complying with their contract documents, which are explicit. Once that change order is denied on liability.
You're not answering my question. My question is, when you go on eBuilder and you want to file this notice of dispute claim, and the contract says you have to include the cost, right? What it is that you're alleging the cost, and there's no spot for it.
Let me.
There are other mechanisms, right? You put together a writing, you mail something else.
Correct.
And there was nothing prohibiting you from doing that.
On this contract, their forms prohibited that. So when we make the claim.
Does the contract say that you have to submit these claims through eBuilder?
No, the notice of claim, so the proposed change order does through their eBuilder program is telling us to do that. Once they deny it and say it's not a change order, it's in your scope, we then file the notice of claim, which goes to the contracting officer who also saw the proposed change order. We are at that point arguing on liability, why it is a change order. If they, and it's happened, if they agree with us, it goes back to eBuilder, and then it becomes a change order that's negotiated.
So then your position is through the practice of this use of eBuilder, which they require you to use, modify the contract in some way?
No, it didn't modify the contract. It actually is the contract. We're complying with their terms. And Your Honors, Your Honor, you stated it earlier. It's the condition preceding file a notice of claim. Every claim in this action has a notice of claim. And in fact, you'll see it in the record. Every time the contracting officer looked at our notice of claim, typically it took them 4 months to make a decision. They came back and asked us for more documentation. We then provided it. Then they would make their determination. It wasn't something done in a day. They looked at it on liability purposes. If they reversed it, it goes back to eBuilder and it's negotiated. Most importantly, NYCHA is aware at all times through eBuilder of what's taking place on the project, and their own form follows the notice of claim because it accounts for what's that work and what's the schedule impact.
Are you arguing then that your time to submit your notice of claim begins to run from the moment that your claim on eBuilder is denied?
Two things, Your Honor. The contract specifications state we can file a claim by submitting a proposed change order. It states that. That's the contract language. Once it goes in, it's initiated a claim. They're aware of it. Once it's denied, if it's approved, it's not a claim. It's a change order. If it's denied, then we file the notice of claim. They're aware of it on 2 occasions. When the change order is filed on eBuilder, which everybody receives at NYCHA, and then once it's denied, which everybody knows at NYCHA, we filed a notice of claim, mailed and filed on eBuilder. It was mailed to the contracting officer and filed on eBuilder because he's also a recipient.
Thank you, counsel. Any other questions? Thank you.
So looking at this two-stepped argument involving a proposed change order and then a later notice of claim, this is not the first time that this court has looked at a NYCHA contract that contains the HUD general conditions and the NYCHA special conditions. This court has already decided cases that had eBuilder, then that had these alleged 2 steps, and the court did not find any such 2-step notice of claim process.
What about, how do you rebut Mr. Pavlovich's affidavit? Does it say that I was instructed to do this 2-step process by NYCHA? Does it say that in the first place? And if it does, what do you do about that?
I'm sure that they were instructed to do a proposed change order when they had changes they wanted to propose. That's a completely separate part of the contract from the notice of claim. So the proposed change order, if you have a claim language, that's in the specifications. That's not what we're talking about, which is the special conditions, which has a specific section on notice of claim and the requirements for a notice of claim. When they look at a proposed change order and say that there's nowhere to put damages, that alone should tell you that is not a notice of claim form. It's not a reason that you can ignore the requirements of a notice of claim. In addition, AWL has unsuccessfully made this a same 2-step notice of claim argument in another case against NYCHA. And Judge Frank rejected that argument, holding it would give the contract unreasonable meaning and inconsistency. The two-step argument is essentially nonsensical. There's no way to follow it and uphold the meaning of the contract as it is written. Anything else?
Thank you, counsel. Thank you both. People versus Desmond Cpio. Okay, counsel.
Good afternoon, and may it please the court. I'm Jihyun Rim with the Legal Aid Society on behalf of appellant Mr. Desmond Cpio. The question before this court today is whether probation serves a purpose for Mr. Cpio, who has already served
Has he already
statutory
served 3 years of PRS?
yes
Okay,
of probation. Yes.
right, probation.
And we're requesting that this court consider his circumstances and reduce his sentence in the interest of justice. Mr. Cpio has demonstrated great rehabilitative potential, despite extremely tragic circumstances very early on in his life, including the murder-suicide of his parents. He completed treatment for alcohol and substance abuse. He received his GED, and he found steady employment, including establishing his own clothing business. He's a resilient young person who, when given the opportunity, betters himself, and over-supervising him is unnecessary. Additionally,
Weren't all of these matters, these mitigating circumstances considered by the people when they made the offer and by the court when it went along with it?
I'm sure it was, Your Honor, but that doesn't prevent this court from considering that again. The court and the...
Prevent us from considering is the waiver of right to appeal.
Sorry, can you...
Waiver of right to appeal.
Mr. Scipio's waiver of his right to appeal was invalid here, and so this court can... So here, the lower court suggested that he was waiving his right to appellate counsel in his plea colloquy, and as a 24-year-old layperson with a high school education and limited exposure to the criminal justice system, this explanation fell short of the care that Mr. Scipio required, rendering the appeal invalid. Additionally, we asked the court to consider the unique circumstances of his arrest. It was April 2020. It was at the height of the COVID-19 pandemic. It was when there was a lot of uncertainty and fear for many New Yorkers. Mr. Scipio was found with a gun under a car seat. It wasn't displayed. And
Loaded.
It was loaded, yes, Your Honor. And it wasn't displayed. There was no evidence that he was intending to use it. In fact, the police only approached his vehicle because they smelled marijuana in it. And he immediately accepted responsibility, and he explained to the officer that he had a gun for protection. And since then, he's not had a new incident, suggesting that he's been making meaningful progress and is unlikely to reoffend. As backed by social science and the DA's offices themselves, over-supervision is not the answer. And whatever positive benefits there might have been to probation that Mr. Scipio could have received, he's already received it at this point. And the fact that he served almost 4 or 5 years of probationary sentence without any new incidents on his part is evidence of that. He served the minimum, and there's no reason for him to continue to serve a year and a half-ish, where Mr. Scipio has demonstrated.
The minimum from what he pled guilty to is 2 years, right? And then the top count, it would have been 3.5 years. So the court had to find mitigation in order to give him a probationary sentence.
That's true.
Why do we have to find further mitigation?
Well, the court and the prosecution found that a probationary sentence was appropriate for Mr. Scipio, and we're not arguing that he could have gotten an incarceration instead. What we're saying is because the lower court and the DA both found that a probationary sentence was appropriate, that's what the baseline should be for what we consider to be excessive. And here, Mr.
So then it should always be the minimum probationary sentence that's optional?
I mean, here he's already served more than the minimum, and that's our point. He's already gone past what social science has said is the appropriate amount of probation to see.
What does the law say? Because 5 years is a legal sentence for probation, right?
That's correct, Your Honor. That's here. What statute mandates is, the probationary statute mandates is that the court should should determine probation as it deems reasonably necessary to ensure that the defendant will lead a law-abiding life or assist him to do so. That's what the statute says. And we're asking that in light of the circumstances of Mr. Cpio's life, that you consider that. Thank you.
Thank you.
Good afternoon, Your Honors. Andrew Loizidi is appealing for the respondent, the Office of Darcy Clark, and may it please the court.
Appeal waiver invalid?
No, it was completely valid, Your Honor. The defendant knowingly, voluntarily, and intelligently waived his right to appeal. Had defense counsel explain all the different rights that he was waiving when he accepted the plea deal, had a written waiver of right to appeal presented to him in which he signed and confirmed on the record that he understood everything he was waiving when he waived his right to appeal, it was a valid waiver. And again, as Your Honors pointed out, all the mitigating factors that defense counsel cites to was already presented before the sentencing court when the defendant pled guilty.
With that said,
yes,
people must have thought that a probationary sentence was appropriate. I mean, you recommended it, right?
Yes, yes, Your Honor.
So now he's served over 3 years of probation.
Mm-hmm.
Why continue it?
Well, Your Honors, considering that, again, he could have gotten a prison sentence, as you pointed out.
That ship has sailed.
Yes, Your Honor. But at the same time, he also hasn't demonstrated why serving the remaining year and a half or 2 years of probation is such a difficult thing for him to do. I mean, he's been doing very well with it thus far. We don't see why he can't, why it's so difficult for him to finish the remaining year.
One might argue that he's been doing so well is because he's under the supervision of
Yes,
probation.
yes, Your Honor, absolutely. So given the fact that he's been doing so well, and again, given the circumstances warranting that led to his accepting this plea deal, the people believe that the sentence is fair and that it's not excessive. And unless Your Honors have any further questions, I respectfully submit on the brief.
Thank you, counsel.
Thank you, Your Honors.
I'd like to quickly respond to what respondent has said about the appeal waiver. As this court emphasized recently in True Love, there's no magic word that makes a colloquy perfect, because the court has to consider the individual circumstances of the defendant, and nothing abrogates that responsibility of the court to make sure that the person before them understands their rights and what they're waiving, not the presence of counsel, not a written appeal waiver, and not a model colloquy. And for a 24-year-old layperson with a high school education, limited experience with the criminal justice, this was not enough. As to Judge Pitberg's questions, besides the diminishing returns of probation after the first year or so, the tenet of probation is that it keeps people from reoffending through supervision. Mr. Cpio is turning 28 tomorrow. That's an age where young adults are really finding their footing in terms of housing, in terms of employment, in terms of finance. And what probation does is add more obligations for Mr. Cpio, which are supposed to be there for its benefit, and interferes with a really important time in his life. Mr. Cpio has shown resilience and rehabilitative potential in the face of extreme difficulties at a young age, and the circumstances of his arrest was very unique and unlikely to happen again, and therefore we ask this court to reduce Mr. Cpio's sentence. Thank you.
Thank you, counsel. Thank you both. Weld versus New York City Department of Environmental Protection.
May it please the court, Remy Green for Appellant Weld. The lower court, mistaken about what oath, quote, has held, deferred to some combination of oath and DEP on purely legal questions. That was error. The error was compounded.
Well, the other side makes the point that the statute does not define frivolous, right? That's correct. And therefore, that shows deference to agency interpretation of what frivolous means.
Well, Justice Moulton, I don't think that that follows. I mean, first of all, a basic rule of construction in New York is that when a legislature uses a commonly used word from another statute, it means the same thing. Frivolousness has a commonly accepted legal meaning. It's used in Section 130.
Among lawyers, it is. I don't know about the rest of the public.
Well,
lawyers know it well, but that 130 definition. But in other words, okay, let me ask you a slightly different way. Would you concede that multiple penalties should not be imposed for a single violation?
No.
You wouldn't concede that?
Absolutely not. I think, and let me just pull out my copy of it.
Like the same 3 minutes of idling can be, if you get two people reporting on them, they can both get compensated?
Right. Well, I think that kind of, that gets into where in the table you are in I think it's A31. Because there are, but for a single 3-minute violation where they also do not pay late, they would only get 1 penalty. But if they pay late, there actually is a second penalty automatically under A33.
Okay.
Right?
But is that penalty for the idling or for the late payment?
I mean, it is an additional civil penalty for the idling for paying the fine late. The structure of the statute, we have three provisions. One that says a penalty for each instance of violating the air code, a second penalty which is a separate penalty for each day, and a third penalty which is an additional civil penalty for paying late. Each of those three is a separate penalty from the other. There is no per day limitation. Of course, to the point, for each instance, there can only be 1 penalty. If that's all that you were asking, then I apologize for fighting.
Has DEP traditionally, or is it their policy to pursue multiple violations that occurred on the same day?
I think there are occasions on which they have done it. Obviously, their current policy is not to. Or at least multiple violations on the same day on the same block so that they do routinely pursue violations when somebody moves to another block and then idles again. And I think that also goes to, it's important that the vast majority of the complaints at issue here are for Amazon trucks or for LabQ trucks. And so for Amazon trucks, they are stopping, moving a couple feet forward, stopping, and they're often idling to charge their phones, to charge their laptops, that sort of thing. The purpose of the air code is to stop specifically that idling. I also, just to circle back on the frivolousness point, the case that DEP cites for saying that there's another definition of frivolous ultimately comes to the same definition of frivolous we always use. On the merits of the two issues, right, the penalty scheme issue and the truck issue, I think the penalty scheme, we have 2 rules of construction. We have the frivolity rule and we have the maximal rule in section 102 that says basically if there's an ambiguous statute or if there's an ambiguity in the reading and the most DEP can manage is just as likely in their brief, we always go with what protects the environment more. On the trucks, I think under any standard, what DEP is doing here is—
Counsel, how can it not be rational for them to rely on the Department of Transportation's definition of truck?
First, again—
Remember, it's a rationality standard. You've got to concede that, right?
No, it's not a rationality standard.
You think it's a matter of law, right? You said— Go ahead, please continue.
It's not rationality because it's a purely legal question. I think the federal courts that have considered this question under—
I don't agree with you about that. Okay. Just for argument's sake, Department of Transportation definition of truck, why can't the—
Because DOT is addressing something entirely different. If you look at the statute that they're importing, and they're only importing part of DOT's definition, because DOT also says it's between 70th Street and 30th Street, it's between 7 a.m. and 8 p.m., it has all these other qualifications. The only thing they're importing is this one thing, and that's specifically for commercial vehicles. What the air code prohibits idling by is trucks, not commercial vehicles.
Okay, I take the point. You get time in rebuttal. Okay. Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the Court, Lauren O'Brien on behalf of the Department of Environmental Protection.
Is the agency in violation of law?
The agency is not in violation of law. The question here is whether DEP's determinations as to a subset of petitioners' complaints was rational, and here it was rational. It provided 2 bases for rejecting, I think it was about 10% of the total number of complaints submitted.
The plaintiff submitted almost 10,000 complaints, right?
In total, yes, and I think it was close to 4,000 in 2023. And the 2 bases that it provided for rejecting the complaints that it rejected were rational. One was that the complaints depicted vehicles lacking commercial plates.
Is there anything in the record concerning the total number of complaints received by citizen complainants? Is there anything in the record about it? Don't tell me if it's not.
I don't think there is anything in the
Okay,
record about
thanks.
the total. And then the other rationale given was where another citizen had submitted a complaint of the same vehicle at the same location on the same day, which is appropriately geared toward rejecting complaints that are likely duplicates of the same violation, which I think there's no dispute that oath will not impose the same penalty for the same violation. And I would like to point to pages 162 through 164 in the record. I'm not sure that I emphasized them in my brief, but there the petitioner acknowledged that it wasn't possible for DEP to know from the video submitted whether the vehicles had turned off their ignition and returned them on. So I think that just confirms that this bright line rule that the agency used to reject a small number of these complaints was a reasonable one, and it was rationally geared towards whether oath was ultimately going to dismiss the complaints if they went forward to oath. And again, I'd just like to emphasize the context. DEP has been inundated in recent years with complaints, idling complaints, and it is charged under the statute with setting out the form in which complaints must be submitted, and also setting out guidelines on its website that's by statute is required to set out guidelines by statute for the types of complaints that must be submitted, and also for reviewing complaints to determine whether they are frivolous or duplicitous. And this was a rational way of carrying out those duties under the statute.
What percentage of complaints made require or has resulted in DEP issuing a written denial, sort of like the one that was issued here?
So all of the if I'm understanding your question, all of the decisions that are being challenged in this appeal are ones where DEP issued a written denial and responded and gave an explanation.
He's asking a more global question.
Is that what normally occurs, that DEP issues a written denial?
So there are cases in which DEP does not respond, and the statute contemplates that when that happens after a certain number of days, a citizen can move forward and bring their complaint to oath. But that is sort of a separate category, and the statute says that DEP plays a role in reviewing complaints to determine whether they are frivolous or.
I asked the question because you mentioned that you were inundated with complaints, which sort of like raises the inference that you have to review every single one of them and answer or prosecute, either or.
It is the case that some complaints will go forward without a response from DEP, but I think, the elements of the statute that I laid out that say that make DEP's role one in which it sets out guidelines for what complaints should look like and sets out the form for which these complaints need to follow. It demonstrates that DEP still plays a role in ensuring that many frivolous complaints are not going forward to oath.
Okay.
Unless your honors have any further questions, we ask the court to affirm.
Thank you, counsel.
Let me start at the end there. Justice Mendez was exactly right. The system they have three options, and one of them is simply letting citizens self-prosecute. That imposes no burden whatsoever on DEP. And in fact, if they are over-inundated with complaints, they just don't have to, they can look, make sure there is a plausible violation, and that's it.
But then is an oath then the agency that would be inundated with complaints, if that were to be the case?
I mean, not everyone who submits complaints is willing to self-prosecute. In fact, that's kind of rarer. But in fact, Mr. Weld's record at oath when he self-prosecutes is very good. And I think that brings me to the truck point and how their use of this rule is the peak of arbitrary and capricious. Record 43, if you look there, you can see that one of the trucks that they're now saying is frivolous to serve a complaint for is one that they have pursued 6 times on their own. And they've achieved violations at oath 6 times. The same truck, same plates, same everything. Arbitrary and capricious is basically when something is no more than a roll of the dice or the flip of a coin. This is a 7-sided die. The one time it came up 1, the time it came up 1, they designated it frivolous, but they themselves pursued it 6 times. That is lightning-like arbitrary and capricious. The other thing, I think, as we talk about rational review, even, if you don't accept that Campion has application here, and if Campion doesn't apply here, I don't know where it applies. But even assuming that, frivolousness in the statute cancels out with the rational standard. It has to. They're not just evaluating whether the complaint has merit, they're evaluating whether it has, to use what their own case, Deutsch says, a facial lack of any, I should quote the exact language, but basically—
I think it's in your brief.
A facial lack of any plausible legal merit. Those two standards have to cancel out. So the court is really just looking at which is the better reading. Just from the face of the statute, it says in each instance, and that's what oath itself has said. At the end of the day, what we're saying here, what DEP is saying is that oath's own interpretation of what complaints have merit is not just wrong, but frivolous.
Okay,
That
thank you.
can't be
Ken.
right.
Thank you very much. Thank you both. American Empire v. Hudson Insurance.
Good afternoon. May it please the court, John McKenna for the appellant, American Empire Surplus Lines Insurance Company. This is an insurance coverage dispute between two carriers about who owes coverage for the contractors involved.
But we're
in the
here
owner.
on the motion to renew issue, right?
This is on a motion to renew, and we're asking for reversal of the denial of the motion for
Why?
renew.
You could have submitted that evidence on your original motion.
Well, Your Honor, the depositions did not take place, so we did not have.
But they did not happen. Is it because you couldn't find witnesses, because you couldn't somehow get them in to be deposed, or because you chose not to?
No, I think in our brief, we indicate that it was a strategic decision to not have a record that's unclear between the two cases, to have one deposition in both cases.
You could have had the deposition.
I don't know if
and
you're
chose to not to strategically, correct?
Well,
and your language wasn't that it's unclear, so it's not to undermine. I think that's kind of two different things. As
I'm
my
not sure
colleague
it's
points out, totally strategic.
Well, we wanted consistency between the two cases. That's what we wanted. But even with that being said,
You're here.
even with that being said, we strongly believe that Hudson had the evidence in its possession from the beginning of our relationship with them and our tenders to them for accepting the additional insured coverage, from the decision of the Workers' Comp Board to their own investigators' reports. We want this case to be in line with the clear precedent that this court has established in situations where the employer is a third-party defendant and they're the named insured. Under that policy, the additional insured coverage is owed, at least for a duty to defend. And that's all we're asking for.
And maybe if we weren't here on a motion to renew, that might be the valid point. But we're really looking at whether or not you could have submitted this before. And again, what does our case law say about strategic decisions?
Well, you certainly, this court has relaxed its rules about motions to renew and whether or not evidence was newly discovered or otherwise obtainable. And again, here, I think we have a strong argument that, to get this case and these facts in line with this court's precedent, and not to burden the underlying court, so that we're not having a trial and having another appeal.
Say we reach the merits. Isn't there an issue of fact about who was actually in control of the scaffolding where the plaintiff in the underlying action fell, Mr. Baronis?
Well, again, I think there is some dispute, and my friend, counsel for the respondent, has raised that in his brief, whether it's on this sidewalk shed or the pipe scaffolding. But I don't think that's where the issue lies with this court and its prior precedent, unless there was clear evidence that American Empire is named insured. Inter was the sole proximate cause, and I don't think there's any argument to being the sole proximate cause. But again, being that they are the employer, being that we have learned of that after our filing of our motion for summary judgment, we ask that this court, with these facts, align the decision from the court below with what it has already ruled on and many
It's
other.
been established that that there is no reasonable possibility of coverage on the part of Hudson in terms of duty to defend.
Oh, the duty to defend is extremely broad, as you know, Your Honor, and all we need to show is that there's a reasonable possibility that Hudson's named insured was a proximate cause. And then, you know, we finally having confirmation from their insured, himself, that Hudson's insured was the employer. You know, we ask that the court reverse.
Thank you, Counsel.
Good afternoon, Your Honors, and may it please the court. Ignatius John Melito for the respondent Hudson. It was not a proper motion for renewal. What happened here was they made a decision to file a note of issue and to move for summary judgment based on what they had. And at that time, they did not have enough. Plaintiff, the complaint, the bill of particulars, his deposition excerpt, all had him working for a different company than the employer here. How do you expect to get summary judgment against the insurer of an entity when you haven't even established on your motion for summary judgment who the employer was or that they were the ones that employed him?
What about the workers' compensation documents?
Well, it's not binding. And Hudson is not the comp carrier, did not participate in that. I don't know what happened at that. We were not in it. So it should not be considered against Hudson.
The American is looking to have Hudson assume the defense.
If they're insured, yeah.
If they're insured. And in order for them to achieve that, this individual must have been working for Hudson's insured.
Unibud.
Which is Unibud. So if let's say that we find that they did not submit sufficient evidence, because this is not new evidence, because they made the strategic decision not to depose these folks, do we need to reach whether or not Inter or Unibud had anything to do with how this accident happened?
Well, if you cannot connect Hudson's insured to the accident based on the record on the first motion, then the case is over there. They have not put in sufficient evidence to establish that it arose out of our acts or omissions when they haven't even established that the worker was our employee. Okay. Now, there was nothing about the accident in the first motion. Nothing. Okay? When they made the motion for renewal, the only evidence about the accident was an excerpt from Unibud's deposition where the Zagroba testified that the plaintiff said that he was walking on the sidewalk bridge and he tripped. That's it.
Who put up the sidewalk bridge?
Inter put it up. Inter maintained it. Unibud was not responsible for this.
So if we find that the evidence that Hudson has submitted is sufficient and that should be considered by the court,
yes,
then we go to the main issue, which is Unibud somehow negligent? And if we find that they're not, then no duty to defend and no duty to indemnify.
Correct. And because it was on the sidewalk bridge, and that was not Unibud's purview, that's undisputed, that's in the record, that the contracts say Inter will build and maintain the sidewalk bridge. And it happened on the sidewalk bridge. Again, page 277 of the record is the testimony in this record. Now, they're asking you to go outside the record and look in the underlying file in Barones. I don't think you should do that. But if you look in that underlying file, they cite to a response to the statement of undisputed facts on the summary judgment motions in the underlying case. That's kind of an interesting document for them to point you to, because it's not really facts, it's just what somebody's saying. If you want to go look at that record, look at document 231, which is Barone's deposition testimony. Look at page 45, where he says, I tripped on the sidewalk bridge. Or look in pages 108 to 117, where he explains that he came down from the hanging scaffolding to get cement. He walked along the bridge, got the bucket of cement, and was walking back on the sidewalk bridge when he tripped and fell.
And what about if we look at the pages of the deposition of, what is it, Cybroga?
It's a broker. It's
Or
on
he
tape.
says that he learned or he heard from somebody that they were walking on the sidewalk bridge when this gentleman Baroni tripped and fell.
That's the only thing in this entire record as to how the accident happened. So if you're going to stay with this record, they have not established fully that it's our employee or that it was our fault. It was on their sidewalk bridge. And frankly, you shouldn't even look at the renewal papers because they're improper. And the original motion was properly denied, and this should be affirmed, and you should grant summary judgment the other way. Thank you.
So I'll dispute with my friend, counsel, for the respondent, that the testimony is clear. The principle of Unibud clearly states that Baronis was the employee of Unibud. That's clear.
What bothers me is you're saying in your memo of law in reply that you made the strategic decision out of necessity to avoid inconsistent testimony that might undermine your underlying action or the instant action. So you made the strategic decision not to depose these people, according to you.
That's right, Your Honor.
Right. So then how is that new evidence? How is that not something that you decided not to?
Well, again, we asked that the court relax the rule for newly discovered facts because we gave a reasonable justification, and again, to get this case in line with the decisions.
Reasonable justification strategy?
Inconsistent testimony.
Okay, so now let's say that we do go ahead and say, all right, this is new evidence, right? Now, can we look at the end result? Is Unibud somehow negligent here? Because they had nothing to do with the sidewalk bridge.
So they don't need to be negligent. It's a cause in whole or in part by standard, so they have to be approximate cause of the injury.
How then are they approximate cause of the injury?
Well, they're the employer, so they had direction and control. I don't think there's any evidence saying that once they, and I'm not agreeing that this was on the sidewalk bridge. I think it's clear from the complaint in the underlying action, from the statement of facts in the underlying action, that this was on the scaffolding. But
that they did not put up.
Right, but they're the employer. So they have obligations for a safe work environment for their employees. The fact that they can't say, well, this is different than, the case of Hanover from this court to say, if the additional insured was a sole proximate cause, then there is no additional insured coverage for that entity.
Okay, thank you.
Thank you, counsel. Thank you both. Beton versus the City of New York. Please.
Sure. If it pleases the court, excuse me, I'm Mark Sokoloff. I'm the attorney for the appellant Beton Court. It is our position that the lower court erred in not following the dictates of this court's decision and rulings in the Pascuti versus Board of Education. That's
Well, you need a special duty, right? You'd concede that.
Excuse me, Your Honor?
In order to get liability, you need to show that there was a special duty. No, you don't need that?
No, you do need it, and we have.
So how did that happen? Doesn't it have to be a specific promise about the child being, that I'm going to protect you from this particular child?
Right. There were several, the Department of Education assumed many special duties upon which plaintiff could rely. There was the implicit duty that at any time there was an assault, the principal, the security guard, the social worker, and teacher's aide would be there to help her.
Well, but didn't the principal say if there's an issue, call 911?
Well, in this particular incident, the 12/17/2014 incident, Betancourt was summoned to an altercation between JD and the social worker. She pulled them apart, and JD shouted, "I'm going to kill myself," and was flung himself into the air.
I know, Counsel, but you just said that the principal, the security, everyone told her that if she has an issue, they would be there.
Yeah.
But when she approached the principal said, if there's an issue, call 911.
She didn't have a chance to call 911. The boy was in flight.
But that's not, but counsel, I think maybe we're focusing on, you're focusing rather, so we need to know what was the, as in the DiNardo case that the Court of Appeals put out, what was the definite enough assurance to generate this justifiable reliance?
Right. Well, JD was suspended, and he was suspended for the benefit of Beton Court, to protect her from the physical injuries.
Just for her?
Well, for her, as well as the students and for JD himself.
So again, counsel, it has to be something a little bit more specific to this particular individual. For instance, you talk about that Pasucci case in 2003, and in that one, we did find that because the secretary acknowledged to that particular teacher who phoned and said, I need help, and the secretary said, help is coming, yes, there was some sort of special duty for him. Where do we have that here?
Well, we have it here because the principal didn't respond to this assault. The security guard didn't respond to the assault. And more importantly, the Department of Education knew about all these occurrences.
How do we know that? How do we know that, Counsel?
Well, it's in the records. You can see if you go to the records, the appellant record, from page 782 through page 848, the Department of Education through SOHO, the hearing officers, suspension officers, got all these occurrences when they happened. And you can see from these records that the student was suspended, and the fact that the student wasn't permanently suspended is a question of fact as to whether or not the Department of Education lived up to their own protocols. On page 731 of my record, you will see it's stated through the deposition of Rosencrantz, a regional superintendent suspension, that's the highest suspension, a permanent suspension. A regional superintendent suspension should be sought when a student engages in behavior which presents a clear and present danger to the student or school personnel. My client relied on a permanent suspension. She got a temporary suspension. The suspension evidences a special duty to Beton Court. She was also promised, and it's in the depositions of plaintiff and the deposition of the social worker, she was promised a walkie-talkie. She was promised better communications with the one security guard. And
Thank you, Counsel. You have time in rebuttal.
Excuse me? Oh, I'm sorry.
You have time in rebuttal. Yep.
I didn't see the red light
problem.
go on. Sorry.
Your Honors, my name is Amanda Abata, and I represent the respondents in this matter.
Was there a special duty?
No, Your Honors, there's no special duty. We know that from Beton Court's testimony. We know that there was no affirmative promise of protection, whether expressed or implied. She herself testified that she knew the safety agent there wasn't hired to protect staff members, that the only concern she had is with the accessibility of the safety agent. When she was asked about the walkie-talkie, she said herself she never remembered asking the principal. She did remember that the principal never promised to provide them.
She acknowledged that the Department of Education didn't know?
Well, yeah, she also said herself that she never complained about the child JD to the Department of Education. She told the principal about there were some physical altercations with the child JD, but she remembered that the principal was non-committal, did not react, never said anything in response to her concerns, never promised to take any action, and just told her to call 911 as needed. And that's something also that's confirmed by Torres, the social worker, who said similarly that the principal made no promises about protection or security or to take any action.
Does it ever come to a point, counsel, where there's such inaction by the principal that there's an implied promise?
I don't think that that case is here. The one case he's relying on, Pascucci, there are clear, distinct differences. Like, we had like 3 phone calls to a school secretary who said, oh, hey, the security's coming. Here, in contradiction to this alleged crisis plan that was unwritten and there's really no evidence that it ever existed, in the crisis plan, I think it was Levenberg and Betancourt later on in her affidavit say, oh, this crisis plan says that if there's a physical altercation, that the safety agent's supposed to be summoned. But on the day of the actual incident with this child, the educational assistant informed her. Betancourt did not call the safety agent. Betancourt did not tell the educational assistant to call the safety agent. She decided to herself go into the stairwell where the social worker was wrangling the child and engage the struggling child. And contrary to my learned friend here, the description of it in the deposition says that Torres, the social worker, had her arms around the child and the child was kicking. So really, Betancourt approached the child as the child was kicking, and that's how she injured her thumb. And the 2 of them wrangled the child, took him to the main office, and then Betancourt again continued to sit in a chair with her arms and legs around the child for 10 minutes before the safety agent showed up. So like that's in direct sort of contradiction to this alleged crisis plan that she's claiming was in place at that time that she relied on.
She said wasn't she promised that there was going to be a crisis plan in place?
She discussed specifically that there was the principal came up with giving the child who'd have some issues an educational assistant to keep him engaged in the school, so sort of just like keep him calm. This alleged crisis plan, she raised that for the first time in the opposition to the city's motion, and in it there was talk of she said she was promised an IEP. Betancourt said in her own testimony that neither she and Torres also said they never referred the child for an IEP because he was a 5-year-old who'd gone to school for the first time and they needed more information before they could figure out if that was an appropriate response. We also have, contrary to all this talk about permanent suspensions, Torres, the social worker, testified she never referred the child for any sort of permanent suspension. So that also was not in place. We already talked about how the walkie-talkies weren't in place. We talked about the fact that this alleged security guard who was going to appear every time there's a physical altercation, that doesn't seem to have been the case.
He was the only one there.
I'm sorry?
Wasn't he the only security there?
There was one security guard there at the school, yes. But we also have Betancourt saying in her deposition testimony that she never requested additional agents. So we have all of that stuff to sort of show that there was no justifiable reliance on a crisis plan that doesn't seem to have existed at the time that this incident occurred. We have that there was no promise. Going back even further, we just have the fact that these pleadings are deficient. She didn't even plead all of this. She didn't have it in her notice of claim, which is fatal. She didn't have it in her complaint. Her bill of particulars and her deposition testimonies can't amplify where like they're all over the place. They're all saying different things. They're not consistent. They don't agree. So given that there's not even one consistent theory running throughout all of these documents, they can't amplify her pleadings. And then just sort of finally, I have to note that even by some miracle, she did actually properly establish that there was a special duty. We still have the governmental immunity with regards to discretionary decisions, of which he cites Rosencrantz. Rosencrantz said that a suspension is one option that you can use for a child. He said an IEP is not an appropriate disciplinary response. He said the principal has a discretion to choose what's an appropriate response in order to calibrate it for a situation like this. So we ask, Your Honors, that you affirm.
Thank you, counsel.
Well, in terms of the pleadings, my complaint basically states quite clearly that prior to December 17, 2014, Plaintiff Leigh Betancourt requested that the defendant, New York City Department of Education, by and through their agents, servants, and employees, provide aid, assistance, intervention, or protection against said disruptive students. And that in paragraph 41 of the complaint, it is alleged that the DOE undertook a duty of care to the plaintiff to ensure her safety and well-being. And paragraph 43, the complaint alleges that the DOE failed to provide aid, assistance, intervention.
But none of that, any of that indicate a specific promise or assurance for the justifiable
Well,
reliance part?
the special, we meet all the provisions of a special duty that's required in both the Court of Appeals case, Cuffey versus New York, as well as McLean versus City of New York. The special relationship can be found when the defendants voluntarily assume the duty to the injured plaintiff. They suspended him. They said we're going to have better communications. They promised her and the social worker a walkie-talkie, which they never met. So there were promises and they weren't met. And there were 40 physical assaults, one with a...
Thank you, counsel. You recite that well in your brief. Thank you very much.
Thank you very much.
People v. Brown.
Good afternoon, Your Honors. Ronald Zapata with the Office of the Appellate Defender for Mr. Shaquan Brown. Mr. Brown's burglary conviction should be reversed and a count dismissed when the prosecution failed to prove that he remained unlawfully in a dwelling. In the indictment, the opening statements, and the summation, the prosecution proceeded on a theory that Mr. Brown both entered and remained unlawfully. And as they do not contest on appeal,
You're not arguing, or you sort of are arguing as well, that a jail cell can't qualify as a dwelling? Or it's more that the action that he didn't stay there?
I have three different sufficiency weighted evidence arguments.
It's a matter of first impression, as far as I'm able to tell, with respect to it being a dwelling.
Yes, Your Honor. So in terms of my argument about it being a dwelling, but while it meets the statutory definition of a dwelling, as the Court of Appeals has stated, you have to look at what the legislature thought of as a dwelling before that, which is why in Joseph and McCrae, it stated that entering, for instance, a basement isn't a dwelling. And so here, it should not be considered a dwelling because a prisoner, a detainee, does not have any expectation right to privacy in their cell. And so then for them...
The Department of Correction, I would imagine, does that apply to other inmates? Are you suggesting that other inmates could walk into any other inmate's cells?
I'm saying that...
The rule book that the manual, whatever it is that they hand out, says the opposite, right?
Yes, it says the opposite. And so, that's precisely, I guess my argument is that a prisoner also does not have the right to attack anyone who goes into their cell. They don't have the right to protect the cell because it's not their cell. So they don't have any
They have a right to say, I'm going in early, can you lock my cell for the night?
They don't have the right. I mean, they can ask. That's the issue here is that would a prisoner be expected? Essentially, what makes a dwelling more penalized for a burglary? It's that the person inside is more likely to cause violence if someone enters because they want to protect their property. Here, the detainee, prisoner, doesn't have any right to protect their property or right to the property, so they're less likely to do that, which is why that wouldn't apply. But there's a second issue to this too, is that then this would mean that a prisoner or a detainee would have rights under the justification laws, which would mean that if they reasonably believe that someone is going to enter unlawfully to commit a crime, to like steal their commissary, for instance, they would have the right to use deadly force against someone who does that.
We all learn in property law that property is a bundle of rights, and so why does it have to be all the bundle of rights afforded a prisoner in order to mean this is a dwelling? In other words, he could forfeit that right because of the unique situation of being in a jail.
Yes,
I just don't see it necessarily being the case that every aspect a dwelling, it has to adhere to the inmate.
And it's the same thing as how the Court of Appeals found that, like, why entering a basement of a residential building is not
But
a dwelling.
there are cases that say that, you know, in a hospital room, that could be considered a dwelling, and that person doesn't necessarily have full control over that particular area either. So,
I would argue they have more of an expectation of privacy there than a prison where
because Fourth Amendment rights are severely diminished for inmates, then they can never have a dwelling. They can have no expectation of privacy for
Yes.
other inmates
and
outside of their no expectation of privacy for corrections.
yes, and in lieu of that, they would have no expectation to be able to protect their cell, their property from invaders such as corrections officers who have a higher.
But we're not talking about corrections officers here because that is a different standard. Someone has a picture in their cell, right? And it's on their wall. Another inmate can come in and just destroy that because they have no expectation of privacy at all.
Yes, and so under the prosecution.
Yes?
Well, that's what I'm saying. They don't, which is why let's turn this around. Let's say that happens, and we go with the prosecution's theory that it is a dwelling. Then under that theory, the prisoner who's in that cell can use deadly force. They can use deadly force, and this is obviously not what corrections officers or officials want. And they
So you're saying that part of the definition of a dwelling is the ability to use deadly force if somebody enters unlawfully?
Well, once something is a dwelling and someone has a license to be in there, under the justification laws, someone is allowed to use deadly force if they reasonably believe that someone's going to burglarize.
But that's under the justification. You're saying justification. We're not alleging any of that here. We're alleging that this is his cell, and no other inmate has a right to go in there. No other inmate.
I'm just talking about the slippery slope that would lead to. What that would lead to if we're saying a cell is a dwelling. I'm worried that my time is running short. May I move on to like the enter and remain argument?
Please.
So as I was stating, the jury instruction stated that the prosecution had to prove entering and remaining. They did not prove remaining unlawfully here. Remaining.
They did not prove that. I mean, I think the reasonable view of the evidence and what the jury clearly found was that he didn't have any authority to enter. So I don't know, upon entering, he had no authority. When does it convert to he now has authority, and that authority has to be revoked so that he could remain?
Unlawfully entering and unlawfully remaining are two completely separate theories under the Court of Appeals.
And is there a fair view of the evidence that they've established both?
No, it is not, because to have unlawful remaining, this is what the Court of Appeals says in Gaines. Quote, to be guilty of burglary for unlawful remaining, the defendant must have entered legally, but remain for the purpose
Must
of
have
committing
entered
a
legally.
crime. Yes.
And your argument is that he entered legally here?
No, so they prove unlawful entering. They did not prove unlawful remaining because they're two separate theories. The theory of unlawful remaining requires a lawful entry, and then
How does that apply? Would that not, are you trying to apply that to now every single burglary case? Because
no, only in this case, because the jury instruction stated that they had to prove, and they went along with this in the indictment and their.
Was this issue preserved below?
It does not have to be, not in terms of a sufficiency argument. I asked this court reach an interest justice, but this court must reach it as a weighted evidence argument. And I could go on, but.
You have time to rebuttal, counsel.
Thank you.
Any other questions? Thank you.
May it please the court, Brent Yarnell for the people. The statute offers two definitions for what constitutes a dwelling. First is a building that is usually used by a person for lodging at night, and second is a unit within a building that is separately secured or occupied and is also usually used by a person for lodging therein at night. I think the case law that my friend is trying to invoke is the case law from People v. McRae and its progeny, which addresses what happens when you have a building, say a hospital that has lots of hospital rooms that are themselves dwellings, but there might be a part of the hospital where somebody doesn't sleep in there and the defendant breaks in there, and you're trying to determine whether that portion of the hospital is a dwelling. That's really the case law that my friend is relying on. This is completely distinguishable because the jail cell itself was a unit within the jail that was clearly a dwelling. It was clearly used for sleeping there in at
your
night.
friend's argument that if we deem this a dwelling now, this inmate can use deadly force?
I don't believe that that's accurate. We certainly have not argued that the victim was justified in using deadly force, or that the justification would flow automatically from qualifying the unit as a dwelling. And I would say that if that's really does exist in the law and that is a problem, then you have to deal with that by looking at the doctrine of justification. You don't look at that by looking at the doctrine of what constitutes a dwelling. So that's not the way that you would address that problem. You would address the problem by talking about when justification exists, not by what constitutes a dwelling. And I would just say also in terms of matter of first impression, I think that is true, but I would look at, obviously the hospital cases are very, very comparable. And then also this court's decision in People v. Cummings addressed a question about whether the defense attorney was provided ineffective assistance for failing to argue that a dormitory within a police station constituted a dwelling. And this court said that he didn't because it wasn't a likely argument to succeed. Turning
to your adversary's argument with regards to the remain unlawfully.
Yes, so I think it's helpful to start here with the definition of remaining unlawfully. So if you look at the statute, you look at the Court of Appeals decision.
Remaining unlawfully presupposes that you entered lawfully.
No, that's nowhere in the statute. The statute says that remaining unlawfully is remaining in a place without license or privilege to do so. That's the way that the Court of Appeals defined remaining unlawfully in People v. Helms in 2017.
If you enter into a dwelling if you unlawfully enter into a dwelling and you remain there, can you be considered remaining unlawfully?
Well, so the Court of Appeals decision in People v. Gaines was that we don't want the people to proceed on an unlawful remaining theory if there is a case where it's clearly an unlawful entry, and that is true. However,
that's your argument here, right?
Well, what we're talking about is what happens in the case where the judge clearly
makes a mistake, right? Makes a mistake and says they have to prove both as opposed to or.
Right, exactly. And so you're not supposed to charge the jury that way, but when you charge the jury that way, what do the charges mean? And Gaines does not say that what the charge means in this circumstance is that remaining unlawfully means entering lawfully but then staying there unlawfully. That's not in Gaines.
If it's interpreted that way, that's an impossible standard for you to meet, right? Under the facts of this case.
Oh, it would be impossible, but it's just that's not what Gaines is saying. I mean, what Gaines is saying, and the core of the holding in Gaines is that burglary as a crime is committed only if you have the intent to commit the crime at the moment the trespass begins. So the problem that Gaines is concerned about is that if you include references to remaining unlawfully in an unlawful entry case, the jury might be confused and they might think that you could enter unlawfully, but then later develop that. Right. And the point here is that, that's what Gaines was focused on. It wasn't trying to redefine what unlawful remaining means. And so that's basically why we win on the weight of the evidence argument. And additionally, even if defendant had preserved his objection, I mean, putting aside the fact that the court might have just corrected the jury charge, we would have a very strong harmless error argument because there's really no question that defendant intended to commit the assault at the time that he entered the jail cell. And the reason that you know that is because you watch the video, you can see that the fight starts before defendant actually enters the cell. So what happens inside the cell is a continuation of the fight that started outside the cell. And so there's really no question at the time of entry, defendant intended to commit the crime. And that's why this clearly was a burglary. And unless the court has further questions, we ask that you affirm. Thank you.
Thank you, counsel.
Thank you.
In terms of the of the definition of unlawful remaining, again, I'll just move back to Gaines again in this quote that Gaines stated, quote, "To be guilty of burglary for unlawful remaining, the defendant must have entered legally but remain for the purpose of committing a crime after authorization to be on the premises terminates." It's a completely separate theory from unlawful entry. You can't unlawfully enter and then stay there and say that that's remaining unlawfully. That's precisely the argument that the prosecution tried to make in the Court of Appeals, and the Court of Appeals rejected it. They said it's a completely different theory, And so here, if they were required to prove both unlawful entry and remaining unlawfully, in terms of if it was an impossible standard, it was up to them to object to the jury charge. This is what the Court of Appeals has stated in Malagon, in Bell, in Rodriguez. If the Court of Appeals places a higher burden on the prosecution, it's up to them to object to that. Otherwise, they have to meet that heavier burden in a sufficiency review or a weight of the evidence review. It's the same exact thing that happened in the Appellate Division's second department decision in People v. Samuels. Same exact type of jury instruction error. The jury instruction was that to prove burglary, you have to enter and remain unlawfully. And the court reviewed the weight of the evidence based on that definition, found they didn't meet that burden for one of those, and then.
I just want to pivot to something else. There was you made the argument that during sentencing, the court made a misstatement in terms of that the defendant testified and was disrespectful to the court.
Yes, Your Honor.
He didn't testify.
He did not.
Right? What should we do with that?
That you should consider that as part of the excessive sentence review. If the court considered the wrong facts, then it's obviously a wrong consideration. And if they can use that to impose an excessive sentence, this court should reduce it. At a minimum, it should remand it back to the court for a resentencing. I see my time is up, and I would also like to note that this court has also, for a co-defendant, already reduced the sentence for a co-defendant in this case.
When you say reduced, that's we ran it concurrent?
I'm sorry?
When you say reduced, the court ran it concurrent?
Did
we run it concurrent, or was it that there was a
yes,
reduction?
concurrent with the assault charges, yes. Thank you.
Thank you, counsel. Thank you both. Last up is Cox v. 36 South Oxford.
May it please the court, Roger Sacker, Newman Ferrara, LLP. I represent the appellants. In the first instance, I just want to make sure that the court saw the supplemental cases that were filed
Yes,
on NYCHA.
thank you.
Wonderful.
We did. We read them.
Okay, great. So to quote famed legal scholar Yogi Berra, this is just deja vu all over again. We have a deregulation challenge here. Deregulation claims are always timely. Liggett, the case from last week, Justice Mendez, you were on that panel, said deregulation claims are always timely. 8 years, 80 years, doesn't matter. The court below dismissed our claims anyway, saying that because we mentioned 421A in passing, or saying we mentioned 421A, we were raising a 421A challenge. It was clear that that was a Scrivener's error. If you look at all of the allegations, multi-paragraph allegations, talking about improvements, how improvements are shown, what improvements they had to do. And those were all incorporated by reference in the counts. It is clear that this is not a 421A case. Second, we have the overcharge component. Once again, this takes us to 13 East 124th Street, and this is Maddox, which was our case. We argued it at the Court of Appeals. We used the exact same paragraph that we used in Maddox, we used it here. And yet the court found that that was conclusory. It's not. It says how much of improvements you have to do, and that they didn't do them. That is a rent overcharge allegation. All the records here are in the landlord's possession and control. None of them were provided us in discovery.
Has anything happened in the pre-certification discovery department? No, right?
No, in fact, we asked the court for a conference, and the New York Supreme Court, for some reason, if you file an RJI without a motion, they will not give you a judge. So we filed one to seek a conference, and we've called motion support. They say they're too busy to do it. So we did that. We wrote multiple emails to the defendants saying, hey, look, we want pre-certification discovery. We're entitled to this. None of this was improved. In fact, they told us, oh, we'll call you next week. Never did. Instead, they filed the instant motion. If there's nothing else, I'll rest on my briefs.
Thank you, counsel.
Thank you. Have a good day.
You too.